Hello, everyone. This is Tyler Crone, chair of the Thundering 36. We are very excited to welcome Dave Larson this morning, who is running for Washington State Supreme Court, to interview with us. Over to you, Dave, to tell us a little bit about yourself. Welcome.
Well, thank you for having me. I very much appreciate the opportunity to be in front of you. I'm running for state Supreme Court position 5. I was a trial lawyer for 23 years doing civil litigation. My last gig was with a large law firm doing litigation all over the country. And the cases I'd work on in Washington State would need 25 chairs to take a deposition in the conference room. I went from that to traffic and misdemeanors as one of in the municipal court system, and it's one of the most purpose-driven things I've ever done. And it's driven me, along with some experiences I had as a civil lawyer, to run for the Supreme Court. I like the Supreme Court justices just fine, but the priorities, we need to have priorities that focus more on the trial courts in our communities. We have a Gender and Justice Commission. We have a Minority and Justice Commission. We need to have a Behavioral Health and Justice Commission. I've been recognized statewide and nationwide in terms of the innovative approaches I've taken, and I want the Supreme Court to take those approaches. I'm not running based on any kind of ideological principles. It's more along the lines of having the Supreme Court represent the folks that we serve, and ultimately make the justice system work for people. We sometimes are too close to it as judges and justices, and so we don't see how it impacts people, how what we do impacts people. And I want to be a voice on the court that actually brings that perspective to our communities. And I can explain as I go what led me to that. But ultimately, the reason I continue to try to run is because I think the people of the state deserve a better system. And I don't mean that being nasty or anything else. It just means that truly the experiences I've had say that we can do a better job in terms of both issues with behavioral health, issues with family law, issues with how we run courts and courts generally. A lot of people don't know the Supreme Court just doesn't make decisions. It also runs the courts and makes all the rules and sets the tone. So thank you.
Thank you so much. Joanna is going to ask our first question.
How would you approach cases asking to overturn longstanding judicial precedent, especially for cases that were decided long ago when Washington State looked differently than it does now?
Well, you'd have to follow the standard that the case law has set forward, and basically, is it clearly erroneous, and is it creating injustices? And that's the analysis you'd have to have. You'd have to look at the arguments of the lawyers, and then you'd have to make the best call you can based on those arguments to determine whether or not that precedent needs to be overturned or upheld. And in many cases, the precedent has been overturned in cases where it's been justified, and has been upheld when it hasn't been justified. But I think as a justice, you got to listen to all the arguments. You have to have an open mind to all the arguments, and make sure you're making the right decision. Again, because the decisions you make are affect public trust and confidence. So if you're going to either uphold, or overturn prior precedent, you got to have a good reason that the people can understand and accept as something that is essential to justice. Because justice isn't just what we deliver in court. The thing is dignity and respect is as important as to eating, breathing, and sleeping. And whoever the parties are, and then the public in general, deserve that respect to have the type of decisions that make sense and that can be trusted, and they came from the right place too, and not from political ideology or agendas, but from truly just the law and the Constitution. The courts need to be kind of the lighthouse in the storm instead of a ship lost at sea. And we've had confidence issues on the federal level, and confidence issues in the state level, depending on what perspective you're coming from. And one of the reasons I'm running is in my own jurisdiction. I ultimately got the key to the city. I was named one of the best leaders in my community because of the way I handle myself on the bench, and the way I make decisions and how I reason. And that's the kind of trust I want our courts. I want people to love our courts, and feel that they are that kind of guidepost that we can look to for how we're supposed to resolve things.
Thank you so much. Anita?
Artificial intelligence, or AI, is not always a well-defined or understood term. How do you define AI, and how do you think the court should approach using AI in day-to-day operations?
Well, AI can be very useful and it can be very scary. I think if we're not careful, we can end up falling into some traps. There's been some lawyers that have gotten into trouble when they've relied on AI to write briefs, and turns out their cases don't exist or whatever. We cannot remove the human element. That's where the heart comes from, is the human element. I don't know that we're ever get AI to give us that kind of heart. And to be a good judge, you have to always be in balance with your heart and your mind. Those have to be in balance. If it's too much mind, then you create injustices. If it's too much heart, you create injustices. It's got to be in balance. And I don't know how we replace that with AI. I don't know how we do. But as far as making things more efficient, less expensive, especially more access, those kind of things, that's absolutely essential that we capitalize on those aspects that help people get access to justice and access to the system and access to outcomes. But hold that arm's length of things that can create those issues. And that's the kind of discernment that we really have to have. If we embrace it and just kind of without any kind of scrutiny, we can end up in trouble. But if we push it away without any kind of opportunity, we're going to perhaps cheat the system. And by the way, when I talk about access to justice, I'm not talking about access to lawyers and courts. I'm talking about access to true justice. The justice that we have comes from how we interact with each other, and the courts are asked to kind of remedy those things either in a criminal setting or civil setting or family law setting. And we always have to have focus that human dignity and respect is the number one product we're delivering. And if we rely AI too much, where it depersonalizes that and makes people feel like they're kind of a computer algorithm rather than a human being, I think that would be the grossest thing we could ever do with AI if we do that, because that's the true intent of the system, is to deliver that.
Thank you, Joanna. Oops, Joanna, we are on mute.
Sorry, I'm pulling up my questions again. The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds, with a distinctly different path to clerk for liberal versus conservative federal judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
Well, that's one of the reasons I'm running too, is I think it started a number of years ago, how we've politicized the courts. We look to the courts too much to resolve political issues, and it does politicize the courts. The courts should be that constant, like I said, the lighthouse in the storm, that constant in the environment. And we cheat the political system when we politicize the courts. The thing about the political process that we enjoy is that everybody has a voice, and the fact is, one of my attitudes is disagreement's an opportunity, not a threat. Because disagreement makes you better, and the political process allows that. And anybody that wants a voice, if they want to sign in, they want to and be heard, they have that voice. And the goal is to reach consensus. And then we end up with laws that we all need rather than laws only some of us want. But when we use the courts, only the parties are involved in that litigation, and the courts pick a winner and a loser. And that's why we've seen so much volatility, and why, when cases are decided, why the next thing is to get the justices, the court stacked enough so we can overturn that precedent. Could we look too much to the courts for those things? I think we have to, in the courts, push back harder on that politicization. I would, if I'm a progressive, or if I'm a conservative, I should seek out the opposite to clerk for me. I shouldn't seek out the same, because if I do that, then I'm going to make mistakes. It's the disagreement. It's that polar opposite of me that's going to keep me from making mistakes and putting myself in a predicament where people don't trust me. And so this idea of alignment just will promote further that division that we have. And I one of my sayings is, we got to find a common ground instead of drawing lines in the sand. And the way we do that is to reach out to people that don't agree with us. And so if the intent is to get it to be where we have perfect alignment ideologically, I think it should be the opposite, actually. I think because it is something that's very important, and that's why we have a adversary system. is to have both sides heard, and then from that comes the truth.
Thank you. Anita will ask our last prepared question.
Tell us a little bit about the continuing education requirements for judges, and how do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? How have you applied these to your work?
Well, it's one thing to go to a class. It's one thing to sit in a seminar and say, "Hey, I'm there." Right? No, it's what we do, and it's what I've done in my courts. My court was the first one to use peer navigators, to have embedded peer navigators that are barrier free. You don't have to go through an attorney, the judge, or a prosecutor. You come into court and you're just walk into court. You can talk to a peer navigator. And the reason I bring these things up is because things like race and those kind of racism are not caused by courts, but aggravated. It's how we treat people. And so my other model is that I run a repair shop, not a junkyard. I always see the human potential. Doesn't matter what you've done or what you've done in the past. There's always potential to be better. And my goal is to have people's lives be better when they leave, when they come in. And what that does is that takes those effects that we have when we're this punitive system that punishes people and pushes on people, and it reinforces this idea: you're no good, or you're substandard, or you're this. It lifts them up and sees the potential. In other words, instead of avoiding punishment, we're looking for the virtues of success. When it comes, I'll give you an example. In my court, our court had in federal way had the lowest turnout of minority jurors. And so what I did, instead of just kind of writing a paper or doing whatever, I partnered with my diversity commission. We wrote 3 op-eds. We went to 2 cultural fairs in a row each year with the Washington State Minority and Justice Commission folks, and we actually reached out to people and discussed the importance of jury service. Talked about the painful history of why people of color weren't serving on juries because of voting laws and everything else. And then ultimately, by the time I left the bench, we had 6-person juries. At least 2, if not 3 or 4, of the jurors were people of color when I left. And it's because it's what you do, not what you say. It's not enough to write something or do something, then pat yourself on the back. You have to actually do things to make the courts work. And that's where the education comes in. If you don't take advantage of the education, then you're just wasting time.
Thank you. We'll now move into follow-up questions. If there are any from the room, I have some, but I'll wait for Anita, Joanna, and Amanda to potentially ask some. Anita.
I'm sorry, I didn't quite understand what peer navigator, what they are or what they do.
Oh, okay. Well, I'm glad you asked, because what a peer navigator is, they have lived experience. They've had some kind of behavioral health issue in the past. They've been through the system in terms of crime. They've gone through training on how to actually walk with people. When I first became a judge 18 years ago, it was kind of, we sentence people, you kick them to the curb. We hope you figure it out. If you don't, we're going to punish you. And so I just saw the problems with that. And actually, Representative Davis from the 32nd and I were sitting in a conference room in Olympia down in the Capitol building, and we were sharing these kind of frustrations. And we came up with the idea of the warm handoff for peer navigators. And so somebody that's trained to that's been there, done that, got the T-shirt, is walking along aside somebody when they leave court to help them be successful. So it's not, and in our contract with Peer Washington, or it was called Peer Kent then, and Peer anyway. That's that. I won't get into the structural of it. But the point is, our contract required confidentiality. I insisted on it because I don't want that person to be able to, because they're not going to come in and tell me, "Hey, Judge, I just used meth," or "Hey, Judge, I just used fentanyl." They're not going to tell me that. They're going to tell a peer. They're going to tell, one of the failures that we see is people going back to the same crowd and giving them a different crowd, different people to go with, people that help them be successful in court.
Thank you.
And that's what a peer is.
Thank you. Joanna, do you have a follow-up question?
Sure. No worries if nothing comes to mind, but is there an example where you think precedent was rightly overturned?
Well, of course. I mean, there's plenty of it. The Brown versus Board of Education is the first thing that came to my mind, because Plessy versus Ferguson was that created this whole nightmare of Jim Crow laws and everything else. It was the courts that did that, that created this separate but equal concept that justified Jim Crow laws. And I can tell you one that I didn't appreciate, and that was Blake, because it actually aggravated the problem. It actually made it more difficult in our courts to work with people. That was the one where it basically legalized drugs. And some people are for legal drugs, and that's fine. And that's the political process. But in terms of me trying to operate in court and help people have better lives, it didn't help. But that was the first one that came to mind, just because it's an example of how the courts failed us, because the Reconstruction after the Civil War was I think by the 1900 we had 2,000 elected black folks working in elective offices in our country, and then Plessy versus Ferguson just put that on its head.
Thank you. I'm going to ask you a follow-up if you don't mind. I will take
No
chair's
problem.
privilege here of you've been talking a lot about human dignity and painful histories. I'm wondering if I'm a parent of a transgender child, a young adult now, and I'm wondering if you could share some of the kind of values or guiding principles by which you would, recognizing that there's only parameters that you can take as a judge of what you can speak to, but what are some of the values that inform how you are going to decide upon and lead in some of these difficult and challenging issues that are going to be coming in front of the court around people's human dignity?
I think the number one, well, it's more of a social issue. More if an issue comes before the court, I can't talk about how I rule, but I can tell you how I feel, how I see people. I think one of the problems we have these days is we categorize people instead of recognize them as individuals. Have you ever heard of the starfish story? You ever heard of that story? It's the one where the child's on the beach throwing starfish back in the water, and an old man comes up and asks him, "Why are you doing that?" "Well, the sun's coming out and these starfish are going to die." And the old man says, "Well, there's thousands of them. How can you possibly make a difference?" "Well, it makes a difference to this one." And what we have to do is look at each of these folks, your child and everybody else, as an individual, as a human being, and not part of a movement, not part of a whatever, but just as that human being, and meet them where they are. And that's where I think that we're creating, on both sides of that particular issue, we're creating problems for that individual who deserves the dignity to find themselves and without and so I think that's as personal as I can get. I'm imagining if it's my own child, I would want them treated with dignity and respect regardless. And that's where it comes down to is that when we create those polarizations, the person that gets churned up in that meat grinder is that individual. And I think we have to stop creating those things where we put those individuals in meat grinders, because we're and fail to recognize that individual as an individual soul on this planet that deserves dignity and respect.
Thank you. We are now at the end of our follow-ups and our formal questions to you, and we have 90 seconds for you to share any closing thoughts that you wish before our interview concludes.
Well, I really appreciated the questions. It gave an opportunity to show my heart, and the thing is my expertise in this area, in the area of how courts run, what we need. I think I want put it this way: if you endorse me, 1 year, 2 year, 5 years, 10 years from now, I want you to be proud of it. That's what I want. Now, one of the questions had to do with partisanship. In my last race in 2024, I lost by 0.61%. What my opponent tried to do, and was false, is paint me as partisan when I'm not. And I hope that if people see that, they can listen directly to me. I'll give you my personal number if you want. You can call me. That there's not a partisan bone in my body when it comes to being a judge. That's the thing. It's why I'm running, because I want judges to get rid of the partisanship. The way I see elected office it's a responsibility, not a power. I'm a servant, not a master. My job is to make sure that I provide that constant where people, if there is a dispute, they can come to a court and know they're going to be treated, number one, with dignity and respect, using procedural justice, which is I introduced into the Washington state courts, that they're going to come out, even if they don't win, they're going to come out on the other end feeling they were treated with respect. One thing that happened, it was a little traffic case that I handled, and I was sitting in McDonald's eating a bowl of oatmeal, and this woman came up to me and thanked me for how I treated her. I had ruled against her and made her pay a fine, but she still thanked me for that. Now, that's a small case. I want everybody to feel that way, regardless of what sides of that case. And the partisanship is killing us in the courts. We have to stop it.
Thank you so much, Dave. We appreciate you being with us. We're going to end our recording now and take you off the spotlight